Dear viewers, in the last session, we discussed directors and appointment of directors. In this session, we will discuss the directors, removal, powers and duties. Objectives. The various ways in which the director of the company can be removed. The various powers that the directors of a company can exercise. It also explains various duties of the directors towards the company and the shareholders. It also deals with the independent director and the number of companies a person can become director. Removal of director. A director may be removed from office by the following: by company in general meeting, by the tribunal, by the company in general meeting. Section 169 of the Act provides that a company may by a special notice and by passing an ordinary resolution remove a director before the expiration of his period of office. The section equally applies to all companies, whether public or private. However, there are exceptions to this section. It does not apply in case of a director appointed by the central government. It does not apply to the case of a company which has adopted the system of electing 2/3 of its directors by the principle of proportional representation under proviso to section 163. A director appointed by the NCLT. Nominee directors. A special notice of a resolution to remove a director is required, that is, notice of the intention to move the resolution should be given to the company not less than 14 days before the meeting. Once the company receives the notice, it must furnish a copy of it to the director concerned, who will have the right to make a representation against the resolution and to be heard at the general meeting. If the director submits a representation and requests the company to circulate it among the members, the company should, if there is some time enough to do so, send a copy of the representation to every member of the company to whom notice of the meeting is sent. This is not possible. The representation may be read out to the members at the meeting. The director is entitled to be heard on the resolution in the meeting, which should be a valid meeting in all its aspects. In LIC of India versus Escorts Limited, 1986, 59, Company Cases 548, Supreme Court, it was held that it is not necessary for the members requisitioning removal of a director to state the reasons or grounds on which they wish to remove the director. The vacancy caused by the removal of a director may be filled at the same meeting, provided special notice of the proposed appointment was also given. The person so appointed will hold office for the residue of the period of the removed director. If the vacancy is not filled at the meeting, it may be filled by the board, treating it as casual vacancy, but the board cannot reappoint the removed director. A removed director may claim compensation for loss of office as a director consequent to termination of his appointment. Removal of director by the NCLT. According to section 242, subsection 2, clause H of the Act, when on application to the NCLT for prevention of oppression or mismanagement, it finds that a relief ought to be granted, it may terminate or set aside any agreement of the company with a director or managing director or other managerial personnel. When the appointment of a director is so terminated, he cannot accept, with the leave of the NCLT, serve any company in a managerial capacity for a period of 5 years. It is necessary that the central government should be notified of the intention to apply for such leave. He also cannot claim compensation for loss of office. Resignation by a director. According to section 168 of the Act, a director may resign his office in a manner provided in the articles of the company. If the articles are silent, he may resign his office any time after giving reasonable notice to the company and the board. The company shall take notice of the same and intimate the ROC within such a time and in such a form as prescribed, and shall place the fact of such resignation in the report of directors laid down in the general meeting. The resigning director shall also forward a copy of his resignation along with detailed reasons for resignation to the ROC within 30 days of such resignation. The resignation shall take effect from the date on which the notice is received by the company or the date, if any, specified by the director in the notice, whichever is later. Where all the directors of a company resign from their offices, the promoter or in his absence, the central government shall appoint the required number of directors who shall hold office till the directors are appointed by the company in general meeting. A managing director or whole-time director cannot, however, resign merely by giving a notice. A formal acceptance of resignation by the company is essential in their case. Independent director. According to section 149, subsection 4 of the Act, every listed public company is to have at least 1/3 of the total number of directors as independent directors. The central government may prescribe the minimum number of independent directors in a class or classes of public companies. According to section 149, subsection 6 of the Act, an independent director in relation to a company means a director who is not a managing director or a whole-time director or a nominee director. An independent director is one who, in the opinion of the board, is a person of integrity and possesses relevant expertise and experience, who is or was not a promoter of the company or of its holding, subsidiary or associate company, who has or had no pecuniary relationship with the company, its holding, subsidiary or associate company or their promoters or directors during the immediately preceding 2 financial years or during the current financial year. None of whose relatives has or had pecuniary relationship or transactions with the company, its holding, subsidiary or associate company or their promoters or directors amounting to 2% or more of its gross turnover or total income or 50 lakh rupees or such higher amounts as may be prescribed, whichever is lower during the 2 immediately preceding financial years or during the current financial year, who neither himself nor any of his relatives holds or has held the position of key managerial personnel or is or has been employee of the company or its holding, subsidiary or associate company in any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed. Holds together with his relatives 2% or more of the total voting power of the company, or is a chief executive or director by whatever name called of any non-profit organization that receives 25% or more of its receipts from the company, or that holds 2% or more of the total voting power of the company, or who possesses such other qualifications as may be prescribed. The independent director has to make the declaration of his independence at the first meeting of the board which he attends, and subsequently every year at the first meeting of the board in the financial year. The company and independent directors have to abide by the provisions of Schedule 4 of the Act. Manner of election of independent directors and maintenance of data bank. According to Section 150 of the Act, the independent directors have to be selected from a data bank which should contain names, addresses and qualifications of persons who are eligible and willing to act as such. This has to be maintained by any institute as may be notified by the central government. The appointment has to be approved by the company in general meeting. The central government may prescribe the manner and procedure of selection of independent directors who fulfill the qualification and requirements stated in the Section 149. Appointment of key managerial personnel. According to Section 203 of the Act, it is compulsory for every public company and every private company which is subsidiary of a public company having paid up capital of prescribed sum to appoint a managing director or whole-time director or manager. It also made it compulsory such companies to appoint a whole-time company secretary. This section also made compulsory for every company belonging to such class or classes of companies to appoint the following whole-time key managerial personnel: managing director or chief executive officer or manager, and in their absence a whole-time director, company secretary and chief financial officer. The above appointments should be authorized by the company's articles of association. A key managerial personnel shall not hold office in more than one company except in its subsidiary company at the same time. Any vacancy of the KMC shall be filled up by the board at a meeting within 6 months from the date of such vacancy. Any contravention of the provisions relating to the appointment of managerial personnel shall be punishable under Section 203, subsection 6. The Act did not provide for qualifications necessary for appointment as a director of a company. Restriction on number of directorships. According to Section 165 of the Act, no person shall hold office at one and the same time as director of more than 20 public companies at a time. Where a director already holding office in 20 companies is appointed, the appointment shall not take effect and shall become void unless within 1 year of the commencement of this Act he vacates his office in some companies so as to bring down the number to 20. That the maximum number of directorships that an individual can hold, including alternate directorship, is 20, of which not more than 10 can be public companies. In counting the limit of public companies, directorship of private companies which are either holding or subsidiary company of a public company shall be included. The section further provides that a company by a special resolution in its general meeting can specify lesser number of directorships than 20 in which a director of the company can act as director. Powers of the director. General powers vested in the board. According to section 179 of the Act, subject to the provisions of the Act, the board of directors of a company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. Once elected and in control, the directors have almost total power over the operations of the company until they are removed. Shareholders' intervention in exceptional cases. In the following exceptional situations, the general meeting is competent to act even in a matter delegated to the board. Mala fide. The majority of the shareholders had the right to control the action of the directors in the matter when they are acting against the interest of the company. Board incompetent. The majority of the shareholders may exercise a power vested in the board when the directors have, for some valid reason, become incompetent to act. Deadlock. The shareholders can intervene when the directors are unwilling to act or, on account of deadlock, unable to act. Residuary powers. The residuary powers of a company reside in the general meeting of the shareholders. Powers exercisable by resolution at board meetings. Section 179 provides that following powers of the company can be exercised only by means of resolutions passed at meetings of the board. The power to make calls, to authorize buyback referred to in the first proviso to clause B of section 68 subsection 2. To issue securities including debentures. To borrow money. To invest the funds of the company. To grant loans or give guarantees or provide security in respect of loans. To approve financial statements and the board's report. To diversify the business of the company. To approve amalgamation, merger or reconstruction. To take over a company or to acquire a controlling or substantial interest in another company. Any other matter which may be prescribed. Powers exercisable with general meeting approval. Section 180 of the Act lays down that the following powers can be exercised by the board only with the consent of the company in general meeting. Sale, lease or otherwise disposal of the whole or substantially the whole of the undertaking of the company. To invest otherwise in trust securities the amount of compensation received by the company as a result of any merger or amalgamation. To borrow money in cases where the money to be borrowed by the company together with the money already borrowed will exceed the aggregate of the paid up share capital and free reserves apart from temporary loans obtained from the company's bankers in the ordinary course of business. To remit or give time for repayment of any debt from a director. Contribution to bona fide charitable and other funds. Section 181 of the Act authorizes the board of directors of a company may contribute to bona fide charitable and other funds. Prior permission of the company in general meeting shall be required for such contribution in case any amount the aggregate of which in any financial year exceeds 5% of its average net profits for the 3 immediately preceding financial years. Power to make political contributions. Section 182 of the Act permitted the companies to contribute money to any political party or to any person for political purposes. The amount should not exceed 7.5% of the company's net profits during the 3 immediately preceding financial years. Contribution should be sanctioned by a resolution of the company's board of directors, and that will be sufficient authorization for all-round validity. Only exception to this rule is government companies and companies which have been in existence for less than 3 years. Power to make contributions to National Defence Fund. Section 183 of the Act authorizes the companies to make contributions to the National Defence Fund. This power can be exercised by both. Contribution can be of such amount as may be thought fit. Duties of directors. Section 166 of the Act made a statutory formulation of directors' duties. Such duties have been spelled out in terms of the following 6 points. Subject to the provisions of this Act, a director of a company shall act in accordance with the articles of the company. A director of a company shall act in good faith in order to promote the objects of the company for the benefit of its members as a whole and in the best interests of the company, its employees, the shareholders, the community, and for the protection of environment. A director of a company shall exercise his duties with due and reasonable care, skill and diligence, and shall exercise independent judgment. A director of a company shall not involve in any situation in which he may have a direct or indirect interest that conflict or possible may conflict with the interests of the company. A director of a company shall not achieve or attempt to achieve any undue gain or advantage either to himself or to his relatives, partners or associates, and if such director is found guilty of making any undue gain, he shall be liable to pay an amount equal to that gain to the company. A director of a company shall not assign his office, and any assignment so made shall be void. If a director of a company contravenes the provisions of this section, such a director shall be punishable with fine which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees. Duty to attend board meetings. According to section 167, subsection 1, clause B, the office of a director will be vacated if he absents himself from all meetings of the board for a consecutive period of 12 months with or without obtaining leave or absence from the board. Duty to disclose personal interests. According to section 184 of the Act, where a director is interested in a particular transaction of the company, he must disclose it to the board at the very first meeting after he had become so interested. The interested director shall not participate in the discussion on the matter in which he is interested in the board. In case he votes, it would be null and void, and the defaulting director shall be punishable under section 184, subsection 4 of the Act. number of board meetings. According to section 173 of the Act, every company shall hold the first meeting of the board of directors within 30 days of its incorporation and thereafter hold a minimum number of 4 meetings of its board of directors every year in such a manner that not more than 120 days shall intervene between the 2 consecutive meetings of the board. The participation of the directors in the meetings of the board may be either in person or through video conferencing or other audio-visual means. The central government may, however, by notification in official gazette, exempt any class or classes of companies such as non-profit associations registered under the Act from holding all these board meetings. Section 174 of the Act provides that the quorum for the meeting of the board of directors of a company shall be 1/3 of its total strength or 2 directors, whichever is higher. Section 185 of the Act prohibits the companies to lend money to its directors. After reading this lesson, can understand that the shareholders have power to remove the directors before their tenure. He will also understand the procedure that directors should follow to exercise their powers. He will also understand the various duties of the directors and the consequences in case they fail to discharge their duties. I hope you enjoy the lesson and we will meet in the next session. Thank you one and all.